ask this next question. When renewing an O-1A visa, is the process as extensive as the initial application in terms of documentation? And do legal fees remain the same as during the first filing?
So the legal fees do go down. I believe it's down to 460. Whereas that initial filing, I think you're paying like 1,055, something like that. And then you're also paying the asylum fee, which is $600. That's tacked onto all the I-129s now. But it is lesser from a financial standpoint. From an evidentiary standpoint, is it as exhaustive? You're supposed to be getting deference. Ideally, you're getting deference because you already have that prior approval. At the same time, I don't think that you're still having to prove that the person qualifies. So yeah, you're probably going to rehash a lot of the evidence that you used initially, because obviously, because that was approved, you're going to want to be able to draw from that. I've found with doing extensions, they're usually easier because not only is the person already qualified, but then they subsequently had 3 years in the United States to continue building up that resume for the O1. It's possible that maybe they've published more work, they've acquired a new patent, they've been a judge on a panel that's prestigious, maybe they've had articles written about them. There's all these things that can happen while you're in the US on that O1 to strengthen the extension. So I think ideally your extension is going to be easier because you've already done the process before. That being said, I would never recommend submitting a carbon copy of the same petition. I definitely think it behooves you to, at a minimum, just show that there's been a little bit more added to this person's abilities to show that they're able to continue qualifying for the O1.